What?
They can't like reinstate my old bond, I think. Because I don't know if they'll even buy me out. I think only my dad has the other charge, the disorderly conduct bond. My dad did pay like I think it was like $585 before.
Well, the case was bound over with the bond from the municipal court. And so now that we're in a new court, we have a new bond that is going to be set today. Now, the prosecutor may ask that the old bond just be continued, but we are free to make our argument for the bond that we want. Now, is this the correct address?
Yes.
Okay.
Now I don't. With my parents, did my dad leave you a voicemail?
Not that I have gotten.
Well, they're out of town until the 29th, so I don't know. God bless you.
Thank you, Your Honor. We're here today in State of Ohio versus Ashley L. Rude, case number 25-CR000216. Defendant is present open court today with her counsel, James Matthews. Your Honor, we're here today on a one-count information that was filed on March 18th of 2025. That one count being domestic violence, a felony of the 4th degree. It's the state's understanding today that the defendant will waive her right to indictment, will plead guilty to the one count in the information. We will ask to defer sentencing so that a pre-sentence report, psychological evaluation, and victim impact statement may be ordered and completed. There's no sentencing agreement, and that is the state's understanding at this time.
All right,
Thank you.
Mr. Matthews.
That is all accurate, Your Honor.
All right, Ms. Rude, how old are you?
32.
And how far did you go through school?
I graduated high school.
Are you a United States citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
Yes.
What have you been diagnosed with?
A couple of things. Intermediate explosive disorder, CPTSD, psychosis, and ADD.
Are you being treated for any of those conditions?
Just for right now, ADD. Possibly I should be starting or beginning to take psych medication for PTSD symptoms.
Have you taken any medication?
Not here, no.
All right. Did you get a copy of the information that was filed in this case?
Yes.
Do you understand that you have the right to have that case presented to the grand jury for them to decide whether or not to indict you?
Yes.
Did you discuss that right with your attorney?
Yes.
And are you going to waive that right?
Yes.
Thank you, Your Honor. Prior to the hearing, I did review the waiver of indictment with Ms. Rude. She indicated that she understood it and that she intended to sign it. Sign on that line.
Your Honor, I've received the waiver of indictment. I witnessed the defendant sign the document and hold the court. Her counsel signed it, and I signed it.
Okay, I'll accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question or you want to talk to Mr. Matthews some more, let me know and we'll give you more time. You understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right? Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have a constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right? If you could not afford to hire a lawyer, one would be provided at no cost. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty here today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of your rights?
No.
Do you still want to plead guilty to this charge?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes.
You understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time that I could sentence you to prison, to jail, or to community control?
Yes.
Domestic violence is a felony of the 4th degree. It carries an 18-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
Your Honor, it's a $5,000.
I'm
maximum
sorry.
fine.
$5,000 maximum fine. Do you understand that? Are you presently on post-release control to the parole authority?
No.
Do you understand your felony conviction will prevent you from owning or possessing a firearm?
Yes.
Do you understand that if a prison term is imposed in this case, that you might have to serve a period of post-release control for up to 2 years under the parole authority after your release?
Yes.
If you are placed on post-release control and you violate any conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
Do you understand that if your violation of post-release control is a new felony, then you could get an additional consecutive prison sentence for that violation?
Yes.
And if that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 18 months. Do you understand that?
Yes.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand, at the time of sentencing, I do not have to follow the recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk to Mr. Matthews before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Absolutely.
Are you satisfied with the advice he's given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No.
All right, Ms. Cutts, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on December 31st of 2024, shortly before 8 p.m., Willowick Police Department officers were dispatched to Bay Ridge condos, which are located on North Marginal Drive in Willowick, Lake County, Ohio. They responded regarding a disturbance involving Ashley Rude, the defendant, and Willis Joyner, at that time was her live-in boyfriend. When officers arrived, they were unable to get in through the door. They had to force entry. When they entered, the officers saw the defendant striking Mr. Joyner on his body. They found a bump on his head. All of this occurring in Lake County, Ohio. Through further investigation, officers learned that the defendant, Ms. Rude, had a prior domestic violence conviction in Cuyahoga County Court of Common Pleas, case number CR 11-551591, dated September 1st of 2011. And that would have been the state's evidence. Thank you.
Mr. Matthews, anything to add to those facts?
No, Your Honor.
Ms. Rude, did you hear what Ms. Cutts said the facts would show if the case went to a trial.
Yes,
And are those facts true?
unfortunately, yes.
All right, what is your plea to domestic violence, a felony 4?
Guilty.
Mr. Matthews?
Thank you, Your Honor. Prior to the hearing, I did review the written plea of guilty with Ms. Rude. She indicated that she understood it and that she intended to cite it. No further questions, John? Okay. Put the date there, 3/24.
Your Honor, I've received the written plea of guilty and judgment entry. I witnessed the defendant sign the document in open court. Her counsel signed it, and I have signed it.
Ms. Rude, is this your signature on the written plea of guilty?
Pardon?
Is this your signature on the written plea of guilty?
Yes,
And did you sign it voluntarily?
yes,
Do you want me to accept your written plea of guilty?
yes.
All right, I'll accept the written plea of guilty. Defendant was present.
Thank you.
Mr. Matthews advised of all of her rights, made a knowing, intelligent, and voluntary waiver of those rights. She understands the nature of the charge, the consequence of her guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary, will accept her plea of guilty and find her guilty of domestic violence, a felony 4. I'll refer this for a pre-sentence report, a psychological evaluation, and victim impact statement. Sentencing will be May 7 at 10 a.m. Mr. Matthews?
Thank you, Your Honor. Ms. Rude would like to address the court as to her bond. This case was bound over as a kidnapping as well as the domestic violence. The kidnapping was a felony of the 2nd degree, and the municipal court set bond at $100,000 with a condition of GPS monitoring. Ms. Rude has obviously been unable to post the bond at that level. She is requesting a bond of $5,000, 10%, with no GPS monitoring. We don't feel that that would be necessary. There has been no further contact between Ms. Rude and the victim in this case, nor does she intend for there to be. Ms. Rude does have a number of personal issues that she must address, specifically with her child. I will defer to Ms. Rude at this point to further explain those issues to the court, Your Honor. Thank you.
Go ahead, Ms. Rude.
Hi, I have a 7-year-old daughter, and since I've been here incarcerated, Child Protective Services and Child Support have contacted me. I have a letter to present. My parents, they have custody of my daughter, or they have my daughter right now. I have full custody of my daughter, and they're watching my daughter, and my parents are in their 80s. My mom has Alzheimer's, and my dad has to take care of my mom. I'm adopted into a really good family, and I feel kind of bad that my parents have to watch my daughter. I am worried that my daughter will be presented or in contact with her biological father. And I grew up in a really good area. I grew up in Gates Mills, and my daughter's never had to been subjected to like gunshots or, stabbings or anything gang affiliated. So if she is released to her biological father, I worry that my daughter will be caught in the crossfire of some serious street violence. So I was just wondering if I could be granted a bond so I can get back to providing and taking care of my kid. Also, I require a CPAP machine. I have sleep apnea while I've been in here. And I'm trying to get back on psych medications I do have a therapist outside of here, and I'm trying to get back into becoming a little more stable. So I was wondering if possibly I could be granted that. Also, I do apologize about this. You'll never see me in your courtroom again. This is a lot. It's very traumatizing, honestly, and it's hard being away from my kid. I talk to her every day since I've been in here, and I missed her birthday. She turned 7, and I've never missed a birthday before. Although the discovery packet, it looks like I'm a monster. I'm not a monster to my kid. I'm a phenomenal mother to my kid, and it's really rough being away from her. So I was wondering if I could just go home.
All right, Ms. Cutts.
Thank you, Your Honor. It is accurate that this case was bound over as a kidnapping and a domestic violence. Though the state understands the request for the reduced bond, there are some aspects that are concerning to the state. In this incident, the police were called because Mr. Joyner indicated he was not allowed to leave the apartment, that he was being blocked, and that the defendant had knives. When the police got to the location, they asked first Ms. Rude to open the door. She indicated she could not. Then they asked Mr. Joyner. He indicated he could not, that she was standing in front of it. They could hear that their voices were close to the door. Nobody would open the door, and Ms. Rude indicated that she was unable to. When they said they were going to kick open the door, she told them not to. Before they did that, they heard commotion moving away from the door, and they believed an assault was in progress, so they did kick open the door, and that's when one of the officers saw the defendant striking Mr. Joyner multiple times inside the residence. There were some knives in the kitchen area with other dishes. When the officers got there, they had Mr. Joyner leave the unit, and they dealt with the defendant. Her then 6-year-old daughter was in the apartment through all of this, as well as the defendant, when she was told she was being placed under arrest and was handcuffed, sat to the ground and would not cooperate, would not get up, would not allow the officers to remove her. She screamed for extended periods of time at the officers, yelling and screaming. Her daughter was there the entire time. She would have her come over and hug her at times and then yell at the officers and scream. This was in Willowick. They only had a few officers on for New Year's Eve. They had to call in Wickliffe and Eastlake officers to come to the location to help physically carry her out of the unit. When they got to the stairs, she did agree to walk. As she was walking, she kept telling them not to touch her and was very verbally abusive. When she was placed into the cruiser, she proceeded to kick the divider between the officer and where she was in the back seat. Short of what happened in the cruiser, everything was in front of her daughter, who at times was in tears. One of the officers, who is sometimes at her school, was talking with her and taking her into the bedroom to try and keep her calm. It was an extended period of time that all of this continued on for, with the screaming and the yelling, to the point that Willowick did not bring Ms. Rude into Willowick Police Department, where they normally do their initial booking before taking her to the Lake County Jail. They took her directly to the jail in concerns of her behavior and how she would act. Thankfully, when she arrived at the jail, she was cooperative with the Lake County Jail staff. But this was a very extended incident that could have been dealt with much more easily. The state is concerned for how she was behaving in front of her daughter, for how she was behaving with the officers, and feel that a higher bond is appropriate, higher than the $5,000. We do think GPS, as well as no contact, would be appropriate. In the past, the officers have indicated that Ms. Rude often will not open the door when they are called to the location, as well as she informed them that she was pregnant, so they cuffed her in the front. She was found not to be pregnant. They said that is also a common aspect. So at this point, we do feel at least a mid-range, if not higher bond, is appropriate even without the kidnapping charge, based on all the scenario that has happened, and in hopes of getting the pre-sentence report and psychological done in a timely, easy manner. Defendant does have prior convictions that include, obviously, the domestic violence in 2011. She also has an attempted aggravated assault in 2012 in F3. I believe there was also a misdemeanor assault in that case, and then some disorderly conduct. While she was initially released following the December 31st issue, and then there were a lot of calls back to the apartment with disorderly conduct and issues between her and Mr. Joyner, with both of them getting arrested at different times. So based on all of that, we do feel that a $5,000 10% bond would be too low for this situation. Thank you.
All right, I'll reset the bond at $25,000 cash or surety or 10%, no contact with Joyner. Mr. Matthews, Ms. Rude presented a lot of information that I'm just not gonna go on her word. If you want some further consideration, then you can file a motion, okay?
Can I say something? Sir,
No.
you didn't present that I had been the victim of sexual assault, and that's why I wasn't able to contact the police.
Well, that's not really a bond issue.
But that's still what the prosecutor said is not accurate.
What she said was accurate. It wasn't inaccurate.
That was not accurate at all. Because, so what's my bond?
$25,000.
So-
it should be 2,500.
When will it be in the system so I can have it posted?
Yeah, still do it tonight.
I think early afternoon, 1, 2 o'clock.
What's her name? The prosecutor.
Alexander Cutts.
I'll come with that.
Cutts.
Ma'am, thank you for letting me have this blanket.
Yeah.
And then when it comes to the punishments, are you able to say that, this is not just some type of domestic violence dispute or whatever,
Well, we're gonna be able to present
like
whatever
happened
we,
in the past, and then I'm not just some weirdo that's gonna just claim to be pregnant. Do you need me to provide you documentation of these things? Cause I don't like how she just presented that, that's ridiculous.
well, I think
You can walk us up.
we'll talk.
Which part did I leave out?
None.
Just check.
Not, she's a character. See y'all.
Definitely needs some mental health, I'll give her that. She's probably like night and day. I had a Mutter on the Lake police officer driving in the fast lane on my way to work, and he jimmied up out of traffic. Because he decided, I don't know if he was hitting 60.
you doing?
Good. Get my place down, talk to you.
Go right in.
Thanks. How you doing today, buddy? Doing all right. I'm all right. Sorry you're here, but you did the right thing, okay? And it might make a difference on what happens to you next, you know what I mean? So, you doing all right? Make it through the weekend? Sucks, right? All right. Look, you haven't been in trouble in 13, 14 years, right? The only thing I gotta tell you is this, you gotta just be straight with me. Did you use after, you told us you had, you know what I mean? Okay. So if you tested today, you think, I mean, you're getting closer, you know what I mean? All right.
I'm gonna test, I didn't do it. After the 19th, I just want to run with it.
Okay, all right. When's the last time, so you used 2 weeks before you came and did the plea, or when you did the plea?
No, what day was that, like the 19th?
Yeah.
First day I came here, I told him I smoked it, that.
I think a week, yeah, a week
that
before,
one.
yeah,
No, and that one.
okay.
That's what I did when I told him I was dirty. I knew I was gonna be dirty. I told the PSI lady I was gonna be dirty. I've been smoking marijuana for 20 years up until that day.
But they're not gonna let you smoke it.
I don't know why I'm not smoking. As long as I don't have to go to jail, I don't worry about that.
You were positive on February 14th.
That was the next day.
Yeah.
March, right?
No, February 14th, you're positive, then they took another one, submitted a pre-sentence interview March 5th, were negative for drugs. Wait a minute, urine screen results. Positive with one. The pre-sentence interview March 5th, were negative for drugs. This is crazy.
I just let you know I don't have my phone on me right now, it's in my car. Okay, my,
He's at Lago since 15. I think what you said here is what you need to say to this judge. Judge, if you give me a chance, I'm not gonna disappoint you. You know, I won't use marijuana. I need to go to work. How many children do you have? 7. They all live with you?
Well, one lives in East Carolina.
The other 6 live with you? All right. All from the same lady?
When I met her, I had associates.
Okay, so 4, 5. Gotcha. Okay. Let me go do my plate.
second row.
Second row. See a judge.
Thank you. You can talk,
Oh, I don't know. Pretty sure.
just no contact.
It's cold out there. It's cold. Yeah, it is. Yeah, well, ready to get this over with.
Got a whole bunch of phone calls this morning. eBay, Craig, Bob's asking.
Tell them I appreciate it.
Yeah, for sure.
Oh, he goes. Sure, we'll see. I was told sometime, no, I'm not. I thought I was. We went to Colorado.
was that Maryland and Baylor?
No, Maryland is CSU.
Yeah, Baylor played Duke.
Yeah.
If Michigan State would have won, only if they would have hit that shot right at the end, and they only would have won by 5, I would have hit 14 bucks.
There are a lot of
Michigan State won, didn't
They
they?
did, but
Yeah, so they
I
played
played it
Duke.
by the spread, and the whole game, New Mexico was beating them, and right at the end, I'm like, oh my god. It's all I needed, was them to lose.
No, that's how.
Been a lot of good basketball.
There has been.
Yeah.
This has been one of the better tournaments in
Yeah.
a long time.
Yeah.
There's not many blowouts.
But,
But,
I do like to cheer for the underdog.
so do I. I wanted Colorado State so bad, but my team's
Morning,
Michigan,
Jim. How are you?
and shocking that Michigan's even where they're at right now.
Now, they said all 4 #1 seeds are still in it,
They are.
Sweet 16.
Hasn't happened like that in a while. Florida almost lost yesterday.
Mean mug.
That place is good food.
It, I was blown away. We were both blown away.
You would have liked it back when it was at the old Avenue spot.
It was just, I was there.
It was over by, closer to 615 there. Remember the Avenue? The old bar restaurant back in the day?
Yes,
It's over by St. Andrews. Is that the church over there? It's kind of by that.
oh, by Drug Mart.
Yeah, over that way.
Yeah.
So it used to be there,
Yes, I do remember that then.
and kitchen caught fire or something. And
Uh,
they remodeled the whole thing too. So, kitchen caught fire, then they bought out Eden Park, because they were leasing that place. Well, that Eden Park, they just bought the property.
So they own it.
Yeah.
Is that a franchise?
No, I don't think so.
Okay, just
At least I
stand
don't think.
I don't think so either.
But anyhow, so Saturdays, you used to have pizza wing deals for like $13. You have personal pizza, it was like probably yay big, and like 10 wings or something like that.
I just like all the all the TVs that they had going.
Oh, yeah, it's nice, what they do with it.
We had baseball on one TV, we had golf on the other, NCAA on the next one.
It's weird, because they have them on the inside and the outside.
Yeah.
It's a weird setup.
Well, see, that's one of the things we're trying to do at the Moose. We have a bar renovation plan going, although I don't know if anybody has seen the plan.
Yeah.
But supposedly we have some architects or designers that have come in and.
You
Because,
gotta get John Tabor.
hmm?
John Tabor, or he does the bar rescue.
Oh, yeah.
I think that's, I know his last name's Tabor, I think it's John.
Well, I've been telling them for years that we're not, the founders of the organization didn't start out to be a sports club bar, okay?
Yeah.
But that's what clubs are turning into. And we have a college, we're in a college town, we're here in Painesville. We're not, stretching, we're not,
You
Yeah.
need younger people in it.
You need to pay, you have to have that place needs renovation. It needs a lot more TVs,
Yeah.
and,
It would look cleaner, I think. It looks cumbersome back there.
I'll be the first one called up on charges if it ever happens, but I've always said they need a, electrical fire at about 1 o'clock in the morning.
Yeah.
Everybody's out of there and just let the place burn.
Yeah, it could use some updating for sure.
Well, what we need
So
is,
is the renovation just the bar area? Like, does it include like flooring for the whole
that I don't know.
78,000 or whatever? It seems like a lot. I mean, when you start throwing in refrigerators and all that, it adds up.
Plumbing, all the plumbing has to be changed.
Yeah.
I think what they were talking about at one time, now that, were you there before they closed the door by where the pool table is?
Yeah.
You know, they closed that now. They walled that in.
Oh, really?
Yeah.
Where's that at?
It was in the corner where the pool table is. The entrance door was here, and then there was another door in the back corner. You could
Where's
go out
the
and,
pool table at? Is it in the main room or?
Yeah.
the back room?
yeah,
I'm starting to draw a blank.
okay,
Is it by the entrance, the front entrance?
yes.
So you walk right into it there, right?
Well, you walk in, turn left.
By the ATM then?
Yes.
Okay, yes.
Yes. The wall that the ATM is against,
Mhm.
you used to have a doorway at the end of that corner. And you used to go out to the patio.
Oh, okay, yeah.
They walled that in. So if you want to get through the patio, you've got to go out the entrance, into the vestibule, and then they cut a new doorway to go to the patio.
Okay.
And you need your fob or your card to get back in. Yeah.
I think you
There
said,
you go. Put your bag up here.
I usually just slide it right
All
there,
right.
but I appreciate it.
No problem.
Anybody here for you?
Hey.
Small watch on the ball.
You should have just stayed here.
So we gotta really talk to them.
It's good
Yeah.
that you treat yourself good.
We're not
But
gonna have
Becky
for the
is.
11, but we'll see if we have to go on the record for them or not.
Okay. That's what I told you. No problem. Here we go, too. Okay. 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 Let's see what we can do here, all right? But I mean, I hate to say it like this, but I'll just say it. History's a pretty good indicator of what's gonna happen, right? History isn't great, even though it's a long time ago, you know what I mean? So, it's kind of uphill, you know what I mean? So if you need help, you need to tell them, you know what I mean? So if they can put you in drug treatment, if you need just help, stop them. Yeah, okay. Do you drink? Okay. 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 Some kind of probation here means that you start out in county jail and then you get local time, then you get probation. It is what it is. Okay. All right.
All rise.
You seated, Ms. Cutts?
Thank you, Your Honor. We're here today in the state of Ohio versus Shahid C. Woodson, case number 24CR001422. Defendant is present in open court today with his counsel, Kevin Spellacy. Your Honor, we're here today for sentencing. The defendant was last before Your Honor on February 14th of 2025, where he pled guilty by way of information to one count of having weapons while under disability, a felony of the 3rd degree with forfeiture specification. At that time, a pre-sentence report and drug and alcohol evaluation were ordered. It's the state's understanding that those were completed and provided to the court, and that all parties are prepared to go to sentencing at this time. Thank you.
Thank you, Mr. Spellacy.
Thank you, Judge. Your Honor, I have had the opportunity to review that report as well as the pre-sentence report in this matter. They both seem to be very thorough and very accurate, and I'm ready to proceed whenever you'd like me to do so.
Go ahead.
Thank you. Judges, I've indicated to you on a prior event, my client, while he has a history, hasn't had much of a history since approximately, I believe, 2011. Additionally, as this court notes, I had him turn himself in on Friday pursuant to a warrant that was issued because he had tested positive both on February 14th, I believe, and March 5th of 2025. Judge, I've asked him about those two tests. He indicates to me that he has not used, since that February 14th test, and that it's just the residual of his unfortunate but daily use of marijuana for a very extended period of time. I can tell you that he is employed. He is employed at a place called Lago, which is a restaurant on the east bank of the Flats. He's been there since approximately 2014. As the court also knows, I'm sure from the pre-sentence report, he has a number of children that he supports and a wife. His wife is in the courtroom with us today, as well as the chef of Lago. The owner is out of the country as we speak, but his direct boss is in the back of the courtroom as well. I'm told that he's a valued employee there. I'm told that he's a good husband, he's a good father, and if he's given an opportunity, Your Honor, I don't think he'll disappoint you. I've indicated to him, as I'm sure this court notes, that his history isn't the best, and if it's a precursor, or some indication of how he's gonna perform, it's not a good outlook. But he assures me that he can follow the rules of this court and would do whatever this court asks him to do to show you that he can follow those rules and be productive. Thank you.
Thank you. Mr. Woodson, what do you want to tell me?
Thank you, Your Honor. I would like to apologize to the courts. I would like to apologize to my family. Since the last time I was in jail, Your Honor, I have become a husband, a father of 6. I'm a hard worker. I've been at my job for over 10 years. And I'm here to tell you, if you could give me probation, Your Honor, I promise I won't let you down. I would do anything I have to do. And I'm here to tell you that I'm not here to make any excuses, just explanations, and I'll do whatever it takes, Your Honor.
All right, you tested positive for marijuana when you went over for your report and then when you came back for your report. So what's the story on that?
If you remember, I told you that day, the 14th, that I was gonna be dirty.
Okay.
And Your Honor, up until that day, I haven't smoked, I promise you. But before that, I had been smoking marijuana for a very long time. And the days, like 20 days, I knew my system wasn't gonna be clean
Okay.
again. I told the PSI, Ms. Newman, that I knew it was still gonna be dirty, but since then, Your Honor, I promise to you, I have not smoked any marijuana.
All right, so you were here on February 14th, right?
Yes.
Okay. And before that, when was the last time you smoked marijuana?
Before the 14th?
Yeah.
I probably smoked the 12th.
Okay. Why did you do that? Because you knew
Your
you were
Honor,
coming here on the 14th, right?
Yes, I'm not gonna lie to you, I was just nervous, and I knew it wasn't the right thing to do, but
All right, so then you were out for 7 weeks, or 5 weeks, right, till the 21st, till Friday?
yes,
Okay. And so for 5 weeks and 2 days, from what you're telling me, you didn't smoke any pot, right?
no, I haven't, Your Honor.
And how did you manage to do that?
Like you said, I just knew it wasn't the right thing to be doing, and I just stopped.
Okay, so you have the ability to stop, is what you're telling me.
Yes, I will.
So that means that you have the ability not to smoke it in the future as well, right?
Yes,
Okay? Because in the past, you smoked it because you wanted to smoke it, right?
yes, Your Honor.
Okay. So that shouldn't be a problem from now on, is what you're telling me.
No, it will not be.
Okay. Tell me about your job.
I'm a prep cook at Lago. I've been there for over 10 years. I love my job. I have my boss here. And that's all I do, Your Honor. I work, go home, take care of my kids.
What kind of hours you work?
I work in first shift, 9 to 5,
Right. How many days a week?
Monday through Friday.
And you've been working there for 10 years?
Yes.
What made you start working there?
I always had a thing for cooking. I love cooking. It's been a passion of mine. And once I got the job, I just loved it there. The job has always been good to me. It's a lovely environment. Everybody is like family there. And they accepted me with open arms, and I just loved that job.
What'd you do before that?
I was working in another restaurant, like Chipotle's, stuff like that, fast food.
How did you get this job at Lago?
One of my friends gave it to me, told me about it, and I've been there ever since.
Okay, when's the last time you had a driver's license?
Probably maybe like 5 years ago.
Okay, why'd you lose it?
I think I lost it because I wasn't paying my SR-22 bond.
Okay. What do you have to do to get it back?
I'm not for sure, Your Honor.
Okay. Well, when are you gonna get it back?
As soon as possible.
The night this happened, where were you going?
I was on my way to a friend's house
Where did the friend live?
off of Babbitt Road.
where was that firearm? It was in some sort of bag, right?
Yes, Your Honor.
Okay, why did you have that?
Your
Because you
Honor,
know you're not allowed to have
I
it,
know
right?
I'm not allowed to
All
have
right.
it. One, the firearm is registered to my wife, which, like you said, I still know I'm not supposed to be around it. And the night before, we had went out, and I just put the gun in my bag, because I didn't want my kids to be able to get to it. And no excuses, Your Honor. I know I shouldn't have had that gun in my possession.
Okay, anything else you want to say?
Just if you give me another chance, Your Honor, I promise I won't let you down. I'm capable of doing all the requirements for probation, and I promise I won't let you down.
Okay, have a seat.
Thank you.
Ms. Cutts?
Thank you, Your Honor. Your Honor, looking at the seriousness and recidivism factors, the only aspect of seriousness is potentially that there was marijuana and paraphernalia as well as a loaded firearm in the vehicle, and he didn't have a valid driver's license to be driving, he was the only one in the vehicle. So recidivism factors that are a little more concerning to the state. Defendant does have juvenile adjudication from 1996, a possession of cocaine, felony 4, and a trafficking in cocaine, felony 2. He began his adult record in 1998 for attempted possession of drugs. He had 2 different charges of that that had been reduced. He had probation violations in both of those cases. He also had a felony 5, possession of drugs, which was also a reduction that he had probation violation on. In 1999, he had an F5 possession of drugs. He did go to prison on that. 2000, loud music in his motor vehicle. 2002, a drug abuse. 2007, he had a trafficking in drugs, felony 3, and having weapons under disability, felony 3. He went to prison in that case. In 2010, he has an attempted trafficking, a misdemeanor was reduced from a felony, and in 2011, a drug abuse. His prior prisons were in 1999 for approximately 9 months, was the sentence, and then in 2007, he was sent for approximately 2 years. He was released December 29th of 2008. So in the past, he hasn't responded favorably with the probation violations in new cases and going to prison. We do acknowledge that it has been an extended period of time since he has any convictions on his record. The state was concerned with the positive marijuana testing. He indicated that he didn't think he needs treatment, but he did say it probably wouldn't hurt. Previously, he indicated that his longest sobriety was 3 years while he was in prison. He did say he tried to quit using marijuana on his own, and that only lasted 2 months. At this point, it appears he is attempting again. It is within the 2-month period still, so there are concerns that the state has about his ability to do it completely on his own with a long-term use. Obviously, testing positive for marijuana is arguably a bond violation depending on if it was new use or where that stands. So obviously, the state is concerned about his amenability based on the past. It has been some period of time, so at this point, the state won't oppose community control. We do feel that jail treatment program would be appropriate. He did indicate that his job will work with his timeframes, and we do feel there should be some level of punishment and treatment involved. He does have 8 days credit as of today. So in addition to jail treatment program, we would also recommend decision point program, follow all recommendations of both of those, a mental health evaluation and follow all recommendations, that he not use any drugs or alcohol, including marijuana, and that his periodic screens come back negative. They have 1 doctor, 1 dentist, 1 pharmacy, sign releases. If he is prescribed any medications, that he only take them as prescribed. They participate in 12-step programs with sponsor and home group. They maintain full-time work. There is the forfeiture for the firearm, the magazine, the ammunition, the marijuana, the THC candies, tablets, pills, pill bottle, plastic baggies, the plastic container, the grinder, the scales, $271 in U.S. currency, and packaging. And then he just be made aware that if he does violate, he would have 36 months of prison over his head. That would be the state's recommendation at this time.
Okay, thank you. All right, I've reviewed the pre-sentence report and the drug and alcohol evaluation. I've considered what you've told me, what counsel has said. I've considered all the provisions in 29, 29, 11, 12, and 13. So you've had problems in the past, as Ms. Cutts has indicated, with possession and trafficking. And you've managed to avoid all that nonsense in the past more or less 14 years. I'm not real crazy about the stuff that you had in that car beyond the marijuana, okay?
Okay.
Because that tells me that maybe you're sort of teetering back, okay? Now, I'm not a marijuana guy. I don't give a shit if it's legal or not legal. I don't care, okay? I mean, nothing good comes of it, or very, very limited circumstance where anything good comes of it. And if you're being honest with me today, you have the 100% ability not to smoke marijuana,
Yes, Your Honor.
okay? And while you're on probation, you're not gonna smoke marijuana.
No, I'm not.
Okay? Otherwise, right? So I'm gonna place you on community control for 2 years. You're gonna serve 8 days in jail with credit for 8. You're to have no drugs or alcohol with screens. I want you to get a drug and alcohol evaluation and follow whatever recommendations they make. Get a valid driver's license and do the decision points program through probation, through the probation department, and follow their recommendations. Maintain full employment and pay the costs and supervision fees. Now, when you get your evaluation, I mean, you've stated to Ms. Newman that you don't think you need treatment, but you would look at it. So if you're truly interested in not coming back anymore, here or anywhere else, and you're gonna be honest in the evaluation, you're gonna make some use of it. If you're, or you can blow it off, that's up to you. I mean, you can do it, you can go and tell the evaluator whatever you wanna tell the evaluator. And if you don't wanna be honest, then if you do need help, you're not gonna get it, okay? But that's up to you, okay? You've lived your life 2 ways. How old are you, 40 what?
45.
45. You've lived your life 2 ways. Up until you're 30, you lived it in and out of courtrooms, and including in prison. Since you were 30, you've lived it outside. So you figure out how you want to do it, okay?
Okay.
All right, now, you got a house full of people you're responsible for, so you ought to kind of conduct yourself in that way.
Yes, Your Honor.
Do you have any questions about your terms?
No, Your Honor.
Any other terms you think are applicable, Ms. Newman?
Your Honor, one of the things we recommended was, oh no, we didn't recommend it, that was from like Jaga, just the mental health evaluation.
Okay. Your license, you don't know exactly what you have to do. Now, you're gonna go over to probation after you get out of jail, meet with the probation officer to go through the rules. And then you're gonna come back sometime next week, I presume, to meet with your probation officer. So what you ought to do is, when you later today, get on the phone with the Bureau of Motor Vehicles and find out exactly what you have to do to get your license back.
I sure will, Your Honor.
Because I want you to write that down and give it to your probation officer next week, and they're gonna forward that to me.
Okay.
Okay, if you don't do that, then that means they don't forward it to me, and I'm wondering, what the hell we're doing here, okay?
Okay.
It ain't that difficult. You're gonna be, it's a pain in the ass, you'll be on hold for a while and all that stuff, but that's just the way it goes,
Right.
okay? You got yourself into this, you gotta get yourself out of it.
No problem.
Any question about the terms?
No, Your Honor.
They're not that difficult, okay? So complete it. If you don't complete it, then the state will file a motion to terminate your community control. If it finds you violated, you face 36 months in prison. You understand that?
Yes, Your Honor.
All right. The items subject to forfeiture are forfeited to the state. Is there anything else, Ms. Cutts?
Just the PRC advisement.
I don't think I have to give it to him unless I send them. So I don't intend on sending him because he's not gonna be back here again.
Yes,
Is
Your
that
Honor.
right?
I will not.
All right, anything else, Mr. Spellacy?
No, thank you, Your Honor.
All right, we're adjourned.
All right.
seated. Go.
Thank you, Your Honor. We're here on the state of Ohio versus Melissa Hotchkiss, case number 25CR261. The defendant is present with counsel Bill Watson. A 2-count information was filed in this case on March 18th, 2025. Count 1 is aggravated possession of drugs, a felony of the 5th degree, in violation of Revised Code 292511A with a forfeiture specification. And count 2 is possession of heroin, a felony of the 5th degree, in violation of Revised Code 292511A. I see in the information the second count is listed as count 3, but there are in fact only 2 counts. It is the state's understanding that today the defendant would like to waive her right to have the Lake County Grand Jury indict this case and plead guilty by way of information to both counts, and there's no agreement as to sentencing.
All right, Mr. God damn it. Not Mr. God damn it, Mr. Watson.
Hey.
Trying to get this information from the 25 case up here, and I can't get it up here. The 22 is up here.
22.
So. This one.
Edit. 25.
Yeah, no, I've got to get all 3.
No problem there.
All right. All right, Mr. Watson.
Thank you, Your Honor. May it please the court. That is my understanding of this morning's hearing. I've had a chance to fully pre-try this matter with the prosecutor. I believe full discovery has been provided. I've also had a chance to discuss this matter with my client. She is prepared this morning to enter a change of plea by way of information. She understands that by doing so, first, that she's waiving her right to have this case presented to the Lake County Grand Jury, and second, by entering a plea of guilty, she'll be waiving certain constitutional rights, and no threats or promises have been made in order for her to do so, Your Honor.
All right. Ms. Hotchkiss, Ms. Hotchkiss, how old are you?
35.
How far did you go through school?
Some college,
Are you a U.S. citizen?
yes,
Are you able to read, write, and understand the English language?
yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
Prescription meds,
What have you taken?
Clotidine,
And when did you take it?
this morning,
And does it affect your ability to understand what's going on here?
no.
Did you get a copy of the information filed in this case?
Yes,
Any question about it?
no, sir.
Do you understand you have a right to have your case presented to the grand jury for them to decide whether or not to indict you?
Yes,
Did you discuss that right with your attorney?
yes, sir.
And are you going to waive that right?
I'm sorry, what'd you say?
Are you gonna waive that right?
Oh, yeah, yes, yes, sir. My bad.
Your Honor, I've witnessed the defendant and Mr. Watson sign the waiver of indictment, and I have signed it myself in open court.
Thank you. All right, I will accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you and a need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm gonna ask you questions. If you don't understand a question, or you wanna talk some more to Mr. Watson, let me know and I'll give you more time. You understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one will be provided at no cost to you. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you could not afford to copy those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of your rights?
No, sir.
Do you still want to plead guilty to these two charges?
Yes, sir.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes.
You understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time I can sentence you to prison, to jail, or to community control?
Yes, sir.
In count one, aggravated possession of drugs is a felony 5, with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, sir.
Count 2, possession of heroin is a felony 5, also a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, sir.
If you plead guilty to the forfeiture specification, you're voluntarily giving up those items. Do you understand that?
Yes, sir.
I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a maximum of 24 months and a maximum $5,000 fine. Do you understand that?
Yes, sir.
Now, are you on post-release control right now?
Yes, sir.
And when were you placed on post-release control?
A year ago this month. I got out of prison in January 24.
Okay.
And I got released from jail though in March, so I don't know when exactly it started because I had a hold in Medina, so I had to go to Medina when I was released from ORW.
Okay, and so were you placed on it for 2 years?
I think it was 3.
What was it, an F3?
Yeah.
Okay. All right. Well, in addition to giving you a sentence on this case, I could give you a consecutive sentence for your post-release control violation. Do you understand that?
Yes, sir.
And I could give you up to the period of time that you have left on post-release control. Do you understand that?
Yes, sir.
Or if you have less than 12 months, I could give you 12 months. Do you understand that?
Yes, sir.
Any question about that penalty?
No, sir.
Do you understand that your felony conviction would prevent you from owning or possessing a firearm?
Yes, sir.
You understand I could suspend your driver's license for between 6 months and 5 years?
Yes, sir.
Do you understand if a prison term is imposed, then you might be on post-release control for up to 2 years under the parole authority?
Yes, sir.
And if you violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir.
If the violation's a new felony, you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes, sir.
The maximum term for that violation would be the greater of 12 months of the time left on post-release control. Do you understand that?
Yes, sir.
You understand if a prison term is imposed, you are eligible for judicial release.
Yes, sir.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 24 months. Do you understand that?
Yes, sir.
Has anybody promised you that I would be lenient on you just because you're pleading guilty?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
Do you understand I don't have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, sir.
Have you had enough time to talk to Mr. Watson before pleading guilty today?
Yes, I have.
Has he discussed everything about your case and answered all of your questions?
Yes, he has.
Are you satisfied with the advice he's given you?
Yes, I have, yeah.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions?
No, sir.
All right. Ms. Gold, if the case went to trial, what would be on the show?
Thank you, Your Honor. The facts would show that on August 12th, 2024, in Paynesville Township, Lake County, Ohio, officers conducted a traffic stop on a vehicle that the defendant was driving and gained probable cause to search the vehicle. During that search, officers located suspected controlled substances, pipe, and a syringe. Those items were sent to the Lake County Crime Lab for testing and tested positive for less than bulk amount of methamphetamine, a Schedule II controlled substance, and less than bulk amount of heroin, a Schedule I controlled substance.
Thank you, Mr. Watson. Anything to add to those facts?
No, Your Honor.
All right, Ms. Hotchkiss, did you hear what Ms. Gold said? The facts would show if the case went to trial.
Yes, sir.
Are those facts true?
Yes, sir.
What's your plea to count 1, aggravated possession of drugs, and felony 5?
Guilty.
What's your plea to the forfeiture specification?
Guilty.
What's your plea to count 2, possession of heroin, and felony 5?
Guilty.
All right, Mr. Watson, have her initial on page 2. I put the meds in there, okay?
It's the same form I will make later. Added that you're doing,
Medicine.
so right below my initials.
Hey, Bob, if he's in here anymore today, have him put a mask on. I don't want to get sick in here, okay?
Probably already gonna get sick.
So sign it right there. And then today is the 24th, so 3/24/25.
Is that it?
Your Honor, I've witnessed the defendant and Mr. Watson sign the written plea of guilty, and I have signed it in open court.
Ms. Hotchkiss, is this your signature on the written plea of guilty?
Yes, sir, it is.
And did you sign it voluntarily?
Yes, I did.
Do you want me to accept your written plea of guilty?
Yes, sir, I do.
I'll accept the written plea of guilty. Defendant was present. Mr. Watson advised of all of her rights, made a knowing, intelligent, voluntary waiver. She understands the nature of the charge, the consequence of her guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept her plea of guilty and find her guilty of count 1, aggravated possession of drugs, the felony 5, and the specification in count 2, possession of heroin, a felony 5. I'm going to refer this for an updated PSR. Sentencing will be May 7, 11 o'clock, and the bond is revoked. Anything else, Mr. Watson?
Nothing further, Your Honor.
Ms. Gold?
Nothing, Your Honor.
All right, we're adjourned. Monchi?
Yes, Your Honor. We're here today for a change of plea in two separate cases from two separate jurisdictions, both involving the same defendant. They're each style of state of Ohio versus Ms. Brianna M. Arnold. Defendant is present in open court today with her attorney, Mr. Ken Nelson. The first case, Your Honor, is case number 23 CR 1194. This is out of Eastlake. Defendant was indicted on 4 counts. This indictment was filed on March 15th of 2024. Each of the 4 counts is a violation of 2925.11a. Count 1 being possession of cocaine, an F5. Count 2 being possession of fentanyl, an F4. Count 3 being aggravated possession of drugs, an F5. And finally, possession of heroin, felony of the 4th degree, that being count 4. Discovery was sent a long time ago. The second case, Your Honor, is case number 24 CR 896. This one is out of Willoughby. The indictment was for 3 counts, which was filed on September 3rd of 24. Discovery has been sent. Each of these is a violation also of 2925.11a. Each is an F5. Count 1 would be possession of fentanyl. Count 2, possession of cocaine. And count 3, aggravated possession. Each of these carries a forfeiture specification, Your Honor. With regard to both cases, we expect the defendant will plead to each of the indictments, Your Honor. There is no agreement as to sentencing. Thank you.
All right, Mr. Nelson?
Thank you, Your Honor. The prosecutor is correct. At this time, my client would like to withdraw her formally entered plea of not guilty in both cases and enter pleas of guilty to the indictments. I've had a chance to review the plea sheets with her. She understands that. I believe it's a knowing, voluntary, and intelligent plea.
All right, Ms. Arnold, how old are you?
30 years old,
How far did you go through school?
all the way in high school.
Are you a
Graduated
U.S.
from-
citizen?
Yes,
Are you able to read, write, and understand the English language?
yes,
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
no,
Have you ever been diagnosed with or treated for any mental illness?
yes.
What have you been diagnosed with?
Anxiety, PTSD, bipolar, depression,
And are you being treated currently?
yes.
Do you take any prescription medication?
Not at the moment, but I was when I was in the facility that I was in.
All right, did you get a copy of both indictments in these cases?
Yes,
And you're pleading guilty to all the charges in each indictment, is that correct?
yes,
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. So I'm gonna ask you some questions. If you don't understand the question or you wanna talk some more to Mr. Nelson, let me know, and I'll give you more time. You understand that?
yes,
All right, you have in each case, you have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
yes.
Are you waiving that right?
I understand it.
Are you waiving that right to the jury trial?
Yes,
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
yes,
Are you waiving that right?
yes,
After the, if you go to trial, the prosecutor is going to call witnesses to testify against you. Do you understand he must prove you guilty beyond a reasonable doubt at a trial?
yes,
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you
Yes.
understand that right?
yes,
Are you waiving that right?
yes,
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
yes,
Are you waiving that right?
yes,
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
yes,
Are you waiving that right?
yes,
You have the right to testify at trial if you want to. Do you understand that right?
yes,
Are you waiving that right?
yes,
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
yes,
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you could not afford to hire a lawyer, one will be provided at no cost. Do you understand that?
yes,
If you file an appeal, You're entitled to have a transcript of all the hearings that take place in this case. You understand that?
Yes,
Are you waiving that right?
yes,
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
yes,
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
yes,
Do you have any questions about any of these rights?
no,
Do you still want to plead guilty to these charges?
yes,
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
yes,
You understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
yes,
Now, in the 23-1194 case, count 1, possession of cocaine is a felony of the 5th degree. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
yes,
Count 2, possession of fentanyl-related compound is a felony 4. It carries an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
yes,
In count 3, aggravated possession of drugs is a felony 5 with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
yes,
Count 4, possession of heroin is a felony 4 with a 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
yes,
All right, now, I could give you a consecutive prison sentence in this case. That means one sentence after another for the separate counts. If I did that, you face a 60-month maximum prison sentence and a $15,000 maximum fine. Do you understand that?
yes,
In case 24-896, count 1, possession of a fentanyl-related compound is a felony 5. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
yes,
Count 2, possession of cocaine is a felony 5 with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
yes,
And count 3, possession of a dangerous drug is a felony 5 with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
yes,
And if I gave you a consecutive prison sentence on that case for the separate counts, you face a 36-month maximum prison sentence and a $7,500 maximum fine. Do you understand that?
yes.
Go ahead, Mr. Funchi.
I just wanted to point out, I believe I made a mistake on count 3 of the 2024 case. I believe I called it aggravated possession of drugs, and I may have done that also on the paperwork, Your Honor, when it should be possession of dangerous drugs.
Okay.
I apologize.
All right, so it is possession of dangerous drug, okay. All right, now, I could give you a consecutive sentence on these cases, one after the other. If I did that, then the total between the two cases would be a maximum prison sentence of 96 months and a maximum fine of $22,500. Do you understand that?
Yes,
And if you plead guilty to the forfeiture specification, you're voluntarily giving up the items listed in the specification. Do you understand that?
yes,
All right, you understand your guilty plea may result in a driver's license suspension of between 6 months and 5 years.
yes,
You understand your felony conviction prevents you from owning or possessing a firearm.
yes,
Do you understand that if a prison term is imposed in this case, that you might have to serve a period of post-release control as part of your sentence after you're released from prison for up to 2 years under the parole authority?
yes,
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
yes,
If that violation is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
yes,
If that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
yeah,
Do you understand if a prison term is imposed, you are eligible for judicial release?
yes,
I could place you on community control for up to 5 years, but if you violate any conditions between these two cases, I could send you to prison for 96 months. Do you understand that?
yes,
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
no,
Has anybody promised you what I will sentence you to in this case?
no,
You understand I don't have to follow the sentencing recommendation of either the prosecutor or your lawyer.
yes,
Have you had enough time to talk to Mr. Nelson before pleading guilty today?
yes,
Has he discussed everything about your case and answered all of your questions?
yes,
Are you satisfied with the advice he's given you?
yes,
Have you been threatened or coerced in any way to plead guilty today?
no,
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No.
All right, Mr. Tavanche, with regard to 23-1194, if that case went to trial, what would the evidence show?
Yes, Your Honor, the evidence would show that on, excuse me, October 22nd of 2023, East Lake PD came upon a suspicious vehicle parked at a gas station. This was in Lake County, Ohio. Defendant was behind the wheel, apparently unconscious. Officers saw suspicious substances in plain view. The Lake County Crime Lab confirmed that at least one of those substances was fentanyl, a Schedule II substance, another cocaine, a Schedule II substance, another methamphetamine, Schedule II, and heroin, a Schedule I substance. That is all.
All right, Mr. Nelson, anything to add to those facts?
No, Your Honor.
All right. Ms. Arnold, did you hear what Mr. Tavanche said the facts would show if that case went to trial?
Yes.
And are those facts true?
Yes.
All right, what is your plea then to count 1, possession of cocaine, a felony 5?
Guilty.
What is your plea to that forfeiture specification?
Guilty.
What is your plea to count 2, possession of a fentanyl-related compound?
Guilty.
What is your plea to count 3, aggravated possession of drugs, a felony 5?
Guilty.
And what is your plea to count 4, possession of heroin, a felony 5?
Guilty.
All right, Mr. Tavanche, if 24-896 went to trial, what would that evidence show?
The state would show that on July 11th of 2024, Willoughby PD responded to a call about a suspicious vehicle that was parked at a trailer park. This was in Lake County, Ohio. The defendant was found in the rear of the seat of the vehicle, found to have an open warrant. Search of her purse yielded suspicious substances that the Lake County Crime Lab later determined that at least one of those was cocaine, a Schedule II substance, another fentanyl, a Schedule II substance, and another search for lean, a dangerous drug. Defendant was previously convicted of a drug abuse offense, Your Honor. That is all. Thank you.
Mr. Nelson, anything to add to those facts?
No, Your Honor.
Ms. Arnold, did you hear what Mr. Tavanche said the facts would show if that case went to trial?
Yes.
And are those facts true?
Yes.
What is your plea to count 1, possession of a fentanyl-related compound, a felony 5?
Guilty.
What is your plea to the forfeiture specification?
Guilty.
What is your plea to count 2, possession of cocaine, a felony 5?
Guilty.
And what is your plea to count 3, possession of dangerous drugs, a felony 5?
Guilty.
Mr. Nelson? Mr. Nelson here.
Oh, I'm sorry, Judge. Do you want her to execute the plea sheets,
Yeah.
Judge? We just have to sign it from the court. Just sign. Yes, as good as you can. Sorry. Today is 3/24/25. And this is the second case. Same thing. Yeah. I thought my handwriting was bad.
Your Honor, I have witnessed the defendant and counsel sign the plea documents. My signature is there on both of them as well. Approaching.
All right, Ms. Arnold, on each of these written pleas of guilty, is that your signature contained?
Yes.
And did you sign each of them voluntarily?
Yes.
And on each case, do you want me to accept your written plea of guilty?
Yes.
All right, on each case, I will accept the written plea of guilty. Defendant was present when Mr. Nelson advised of all of her rights, made a knowing, intelligent, voluntary waiver. She understands the nature of the charge, consequence of her guilty plea, and the maximum penalty, finding them to be knowing, intelligent, and voluntary. I will accept her plea of guilty on 23-1194 and find her guilty of count 1, possession of cocaine, a felony 5, and the specification. Count 2, possession of a fentanyl-related compound, a felony 4. Count 3, possession of drugs, a felony 5. And count 4, possession of heroin, a felony 4. On 24-896, I will accept her plea and find her guilty of possession of fentanyl, count 1, a felony 5, and the specification. Count 2, possession of cocaine, a felony 5. Count 3, possession of drugs, a felony 5. And refer each case to the probation department for a pre-sentence report and drug and alcohol evaluation. Sentencing in each case will be April 30 at 2:30 p.m. Mr. Nelson, you wanted to speak as to bond?
Your Honor, if I may, I know that my client has a poor history of reporting to court. However, since our last time in court, I believe it was in September, she's completed square one inpatient drug treatment. Just looking at her physically, she looks a lot better today than she did back when I met her in September. So I truly believe that she's on the path. That doesn't mean she hasn't slipped up, that she hasn't had a couple relapses, but I think that she's certainly on the path to recovery. If the court would reinstate her personal bonds that were issued previously in this case, she understands that if she did not show at the time of the sentencing, that would reflect negatively on her, to say the least. So we are in the process of defending a child custody matter. It would certainly help her case, and it would help me preparing for that matter if she was out on bond, so that she can come to my office and help me prepare for that. So I am requesting that the court reinstate the personal bond that it had issued for her on both of these matters.
Your Honor, we would object to the reinstatement of bond. We've been trying to get these matters situated since last July. Defendant was offered treatment in lieu, did not show up for that. With regard to these particular cases, she was out on a warrant for one when she picked up the second set of charges, Your Honor. We would object.
All right, where you been since November?
Well, I went to square one, and then after that, I did go to the probation. I got COVID, and then after COVID, when she rescheduled to a different date, that was when I missed it. But I wanted to make sure I went to my son's court first before.
Okay. What'd you do at square one?
I completed it.
When?
What did you do?
When?
It's on the paperwork. October, right? Yeah, October.
Where do you live?
I live in Willoughby, off of Euclid Ave, so 37223 Euclid Ave.
And who do you live with there?
My mom lives there. I live there. That's where my child was subsiding, but now he's with his father until we can get this all taken care of.
Where's your custody hearing?
Out here in juvenile.
All right, what I'm gonna do is I'm gonna reset your bond. I'm gonna release you on each case on your own recognizance. You're gonna sign some paperwork, but what that in essence means, if you don't show up if you don't show up at probation and then at your hearing, then in addition to dire consequences here, you're gonna pick up another felony 4 charge on each case. You understand that?
Yeah.
So you are to, I'm gonna release you on your own recognizance.
Thank you, Judge.
And you're gonna meet with probation. You're also gonna be subject to being called in for a random urine screen.
Okay.
If you don't show up at that, your bond will be revoked and you'll spend the time in jail until the sentencing. You understand that?
Yes.
Anything else, Mr. Tavanche?
Nothing from the state, Your Honor.
Mr. Nelson?
Judge, the sentencing date was April the 30th. I just didn't catch the time.
2:30.
Thank you, Judge. I appreciate it.
All right.